Hello to all of you here in Saxe Auditorium, and hello to all of our friends who have joined us online from across the country, including some on the West Coast who are spending their mornings with us. So I look forward to these events. I look forward to our program on dispute resolution events, not just because we have fantastic speakers like our speaker today. I also treasure and look forward to the community that gathers for our events. It's just wonderful to be here with all of you today. Thank you so much for joining us. So welcome to the 2022 Lawrence Lecture. My name is Katrina Lee. I teach legal negotiation and I serve very proudly as our director as the director of our program on dispute resolution. The Lawrence Lecture and the Lawrence Negotiation Competition, they go together. They are very special, much anticipated events for our program, for the Moritz community, and for the dispute resolution field. Thank you, Jim Lawrence, our good friend, for your support. And I promise you, you are in for a treat today. Our speaker will be discussing a critical topic near and dear to me. I had the privilege of chatting with our speaker several times leading up to today's event, and I have already learned so much from her. Dean Davies will very shortly introduce our Lawrence lecturer. But before I welcome Lincoln to the stage, I have some important business to take care of. Our Lawrence negotiation competition has now taken place here at Moritz, and I have the honor of announcing our winning teams. So I ask that you hold your applause until I have finished sharing the list of our top finishers. So our fourth place team, Greg Seymour and Jimmy Hinton. Third place team, Anthony Long and Stephen LeBoy. Second place, Lexi Moore and Lexi Sikorsky. And our first place team was Abby Counts and Lexi Breitenstein. Please join me in congratulating our winning team and all of our Lawrence competitors. And a big thank you to all of our volunteer judges who included competition alum, former competition winners, and also mediators from the Ohio Supreme Court and from the Sixth Circuit. Thank you to all of our judges. Thank you to our moot court student bailiffs. And thank you to Professor Bill Froelich and to Hannah Laubach for all of their leadership and their hard work in making the negotiation competition event happen. Thank you to everyone. And now on to the Dean's introduction. I am pleased to invite to the stage and your Zoom screens the 20th Dean of the Moritz College of Law, Dean Lincoln Davies. Dean Davies.
Good afternoon, everyone. It's my privilege and honor to welcome you to the 2022 Lawrence Lecture on Dispute Resolution. As Professor Lee mentioned, this year's lecture is one of the highlights of several events here at Moritz connected to dispute resolution and negotiation. And as we begin, I want to echo Professor Lee's thanks and gratitude toward Jim K. Lawrence, a 1965 graduate of the law school who generously supports not only this lecture, but also the Lawrence Negotiation Competition. And congratulations to our student winners of that competition, really wonderful. As well, I know many of the students who are part of our dispute resolution program are here in the audience today, as is Jim, and so we want to thank them for being here and thank all of you for being here. It's because of events like these that are made possible from the support of our alums and our donors and friends of the college that our program on dispute resolution continues to be one of the hallmarks of the college and one of the best programs in the country, currently ranked #1, and for 3 of the last 7 years ranked #1 in the country. So something we're very, very proud of here at the college. This afternoon, I am pleased and honored to welcome Stacia Jones, a member of the Moritz class of 2000, to the Saxby stage to deliver this year's lecture entitled "A Better Way to Negotiate," a better way to negotiation that drives toward equity and justice. Stacia's work is focused on the intersection of diversity, equity, and inclusion and justice for her entire career. She began working here in Columbus at Voorhees Sater, and then went in-house at Abercrombie and Fitch, where she was vice president and associate general counsel and led Abercrombie's global office of diversity and inclusion as chief diversity and inclusion officer. While at Abercrombie, she worked with and mentored Rebecca Joseph, who was a member of the Moritz class of 2022, who would eventually become editor-in-chief of the Ohio State Journal on Dispute Resolution. If you see a theme here, I think we see this all the time, Buckeyes paying it forward toward other Buckeyes. After spending time with Microsoft, Stacia became Global Vice President, Head of Inclusion, Diversity, and Equity at Action at Lululemon, where she leads a team of more than 20 to embed inclusive excellence throughout the entire company and at every level. She is the inaugural Dean's Impact Scholar for the Foster School of Business at the University of Washington, where she's teaching a class exploring the impact the employment law, employee activism, and customer loyalty have on corporate diversity, equity, inclusion. And as a student here at Ohio State, Stacia was deeply involved in our dispute resolution program, working as a research assistant for Dean Emeritus Nancy Rogers, who at the time was the program director. Her intellectual energy her intellectual energy was indeed focused on the intersection of dispute resolution, equity, and justice, and her journal note published in the Ohio State Journal on Dispute Resolution was entitled Confidentiality in Discrimination-Related Mediation Disputes. So we're delighted to welcome her back for today's lecture, which will draw on more than 2 decades of experience to demonstrate that lawyers and corporate executives can accelerate meaningful progress toward parity and justice by consciously engaging in negotiations, decision-making, and advice that challenges exclusionary institutions, systems, and standards. Through her talk, we're all going to be encouraged to use our negotiation acumen in a manner that best represents your client and drives toward a more just and equitable society. So please join with me in welcoming to the stage Stacia Jones, our 2022 Lawrence Lecturer.
Thank you. Good afternoon, everybody. Thank you, Dean Davies. Thank you, Katrina Lee and Bill Frolick, for making all of this happen. To all of the professors and staff in the Alternative Dispute Resolution Program, and a special shout out to Dean Rogers, who I know is out in Zoom land, who was an inspiration and motivation for me in the field of ADR. It is my pleasure to be here today to talk about what motivates me and is passion of mine. I am a firm believer in the power and impact of alternative dispute resolution. I have been practicing various forms of ADR, mediation and arbitration and negotiation for the past 22 plus years that I've been practicing. And I've been doing so here in the United States and also globally. I believe that through negotiation, we have the power to influence, to drive knowledge, and therefore to make significant changes. In addition to my love for ADR, I have over the past few years been deeply invested in looking at race and culture, looking at issues of inclusion, diversity, equity, and justice as it relates to different facets of our society, different communities in our society. I have been looking at where we are from an equity and equality perspective, looking at how we have gotten to the place where we are, looking at those areas where there has been progress, and looking at those many areas where there has not been progress. I have been looking over my career over the past 20-something years and looking where I, as a lawyer, have been a part of the progress, and in those areas where I have hindered progress. And all of those things, all of my interests bring me right here today in front of you all to talk about how lawyers, and that's lawyers who believe in the rights and the freedoms that the law purports to give, how we as lawyers can, through strategic and informed negotiations, help to accelerate our path as a society towards a more equitable place. And so that is where we are going today. Make sure that I remember. Okay, good. So when we talk about negotiations, of course, our lives are a negotiation. We negotiate with ourselves over what we're going to wear on a particular day. We negotiate with our families. From a professional standpoint, as lawyers, we negotiate in a formal way when we sit across the table or across Zoom from an opponent. We go back and forth to reach some sort of resolution, some sort of conclusion. There is also the everyday negotiation or the everyday interactions that we have with our clients to give them advice, to be a part of management decisions, and to do so in a way that our clients actually adapt the advice that we are giving them. That is the type of negotiation that I'm going to be most focused on today. It is through that negotiation that we have the power to influence. When we talk about negotiation, for those of us lawyers and soon to be lawyers who understand how to negotiate and how to use influence, we can use persuasion to get results that are beneficial to our clients. For those of us who are part of the progress, when it comes to negotiation, we are the best at driving radical change that makes our clients and our society better. There are also those of us who are good at negotiation, but we're not good at progress. We're part of a hindrance. And those individuals are best at advocating blindly to a client's demands without context or care for impact to maintain the status quo. I believe that through negotiation, that those of us who are responsible lawyers, those of us who believe that the law gives certain rights and freedoms, and we want equity through what we do and practice in law, that we take from our legal toolbox, one of the most prolific tools in there is negotiation, and we use that to educate, to support, and to convince our clients to be responsible from a corporate perspective. And then going through that, we can come and transform society. Now, if we're a hindrance, we of course block and we're not educating and supporting and convincing to be corporately responsible. That is not the type of negotiation or lawyer that we're talking about today. We are talking about us understanding that we have a legal responsibility and being motivated to drive towards this radical transformation in our society. Now, that I am going to talk in just a bit about the ways in which I think that we can adjust how we negotiate to get to a place where we can educate, inform, and cause that radical transformation. But before we get to the fix and talking about that in more detail, let me talk a bit more about the problem. And the problem that I am talking about is where we are as a society from an equity standpoint. And so in doing that, I want to use an analogy from a book that I read earlier this year or last year, Caste. Caste was written by Isabel Wilkerson, who is the first Black woman who won a Pulitzer Prize in journalism. This was on Oprah's list of readings in 2020. And in this book, she uses an old house as an analogy for the United States and where we are culturally and where we are from an equity standpoint. I really like this analogy because when a lot of people talk about where we are in the United States, a lot of us talk about, well, we weren't here. We weren't the ones who built certain laws, and how are we to be responsible for it? When we look at the United States as being a house, we are looking at a house that was built hundreds of years ago. This house was built by a single demographic, white men, who were in control at the time. When this house was built, there was slavery here in the United States, and there was a hierarchy that was based on race, that was based on gender, based on various factors. And the foundation for this house, the boards that were put up in this house, the walls, the roof, all of that had certain bias and injustice that was built into it. We were the land of the free, but it was for certain individuals. So all of us now in 2022, we occupy this house that was built hundreds of years ago. But in occupying this house, whether we have access to all the rooms in the house, whether we feel comfortable in the house, whether we feel just natural and can kick back in the house, whether we are in the lower levels of the house or if we're able to access and go to the top of the house, all of that is dictated by what was put into place hundreds of years ago. As current occupants, we can't do anything about what happened in the past, but we can learn and understand from it. We must know that if there are certain cracks in the wall, why are there cracks there? If we have pipes that are busted, what led to that? And we are responsible as current occupants of this house to take action and to make change. And I believe, again, as lawyers and through negotiation, we can demolish certain parts of this house. We can rebuild certain parts of this house, repaint where we need to repaint, so that we can move forward and accelerate towards a place of equity. Now, when pulling down the walls and we're looking at the boards and the frame of the house, we really do think of the law. Laws and the practice of law are as old as our country. So when we're thinking about this analogy of a house, best believe that laws, the Constitution, the Bill of Rights, et cetera, are all throughout this house. They have been developed over hundreds of years. They form the foundation of our country and reinforce our cultural norms and values. They protect our way of living. They protect privilege. They protect or cause or oppression. And the practice of law protects those who create the law. And because of our history of unfairness and inequality with respect to specific groups, our structure, the law, and the practice of law are heavily influenced by bias, stereotypes, and a singular focus that does not serve the masses, does not serve marginalized groups. I want to use an example to help us to kind of dig deeper into this house and its foundation in law and what law does in this particular house. And I want to do so by talking about the Civil Rights Act. But let me go back to hundreds of years before that. And again, we know that slavery was prevalent throughout the United States. And there were laws that were in place to keep people enslaved and to control the enslaved population. We advanced to the Civil War and slavery is abolished. We have Reconstruction. In Reconstruction, right after Civil War, there were laws that were passed that allowed Black men to vote. There were Black men who were voted into the government. There were schools that were started that Black children and white children were able to go to school together. There were 40,000 families or so that were given 40 acres. Black families that were given 40 acres, and a number of things that that happened during this Reconstruction period. So when we go to our house analogy, we called the demolition crew, the construction workers, the painters, they're all ready to go and do major reconstruction on the foundation of our home. A reconstruction lasted only 7 years. And so although the papers were drawn up on the reconstruction and what was going to change in the foundation and in this house, it never came about. And so after 7 years, Reconstruction ends. So then we have in our house, we continue to have the same framework in place. So even though slavery is gone, we now have the hierarchy from a race perspective, from a gender perspective, that now is reinforced in a different way. Because again, this house has not changed. Our foundation and our walls are still there. Our foundation and frame create an environment that oppresses all but the single demographic that it elevates. They create a cultural beliefs, institutions, and structures that sustain inequality and without radical transformation, continue to reinforce inequity even after slavery was abolished in Reconstruction. So after the Reconstruction, we then have about a 100-year period, okay? And again, slavery is gone, but we have legalized discrimination. We have legalized segregation via Jim Crow. So we get to the 1960s and we have the Civil Rights Movement. We had the Civil Rights Act of 1964. And so like the first Reconstruction, we believe that we are now at a place that again, the demolition crew has been called. The construction workers have been called. Okay, we are now actually going to make major changes so that individuals can have an opportunity in this house to be comfortable in it, to access the extra rooms in it, to be able to go anywhere in this house that they would want to go without any sort of hindrance, without any sort of barrier. So did that happen with the Civil Rights Act of 1964? What I want to talk about and how I want to talk through this and what happened with this demolition crew that was ready to go in 1964, I want to talk about what happened through the Kerner Commission, okay? And with the Kerner Commission, this was a panel of 11 individuals who were asked by President Johnson to do an extensive report on a number of riots that were taking place. So we have the Civil Rights Act of 1964, and from 1964 to about 1967, there were a number of riots that were happening in major cities around the United States. President Johnson is like, okay, with this house, going back to that analogy, we have the demolition crew, we have the construction workers, we're ready to make this major change. We have the Civil Rights Act of 1964. What in the world is going on with all of these riots and things that were happening? And so then we have the Kerner Commission that came into place. And the Kerner Commission was to look at what was happening with the riots and to figure out what's going on? What should we do to move beyond this place? So with the Kerner Commission, they looked at what is the problem. Importantly, they did not find that the problem was crime and lawlessness amongst Black Americans. It's really important because our house and the foundation of it, it is based on a belief that Black Americans are subhuman and that that crime and lawlessness is just something that we do. So that is a part of the framework of the United States. The Kerner Commission said, no, that is not the problem here. The problem is white racism and the ghettos, which were where Black people were being pushed to live. So that is the problem. The fix, the Kerner Commission said, is not in massive investment in punitive patrol. So it's not calling in the police. It's not trying to criminalize behaviors. The way to make a change, the way to invite those demolition workers in and actually start the work on this house to be able to reinforce the Civil Rights Act of 1964. In order to do that, we must pour massive investment in poor Black communities. That there would then help to reinforce the Civil Rights Act of 1964, help with progress. And so the question, of course, is, did we do that? And we did not. Instead of doing as the Kerner Commission indicated and taking money and funneling it to Black communities, instead our government invested billions of dollars in highly militarized police forces. Instead of giving money to education, et cetera, the government incarcerated Black communities at astronomical rates and then slashed funding for education, public housing, and welfare. As you can see up here on this slide, the United States and federal prison population increased 800% in just 40 years between President Nixon's war on drugs and 2012. And so we went from under 400,000 to 1.6 million incarcerated individuals. That was instead of doing what we should have done to reconstruct this house. I have a quote here that I like to put up from a member of Nixon's 1968 strategy. It says, "We knew we couldn't make it illegal to be either against the war or Black, but by getting the public to associate the hippies with marijuana and Blacks with heroin, and then criminalizing both heavily, we could disrupt those communities. We could arrest their leaders, we could raid their homes, break up their meetings and vilify them night after night on the evening news. Did we know we were lying about the drugs? Of course we did." So this just goes to illustrate the extent to which people will go to reinforce this house, the foundation, and not make change. I like this quote here from Professor Leon Litwack, right at the end of the 1900s, as we were going into the 21st century. He said, "At the dawn of the 21st century, it's a very different America, and it's a very familiar America. Everything has changed, but nothing has changed." I put this quote up here because it is important for us to understand that until we change our values, until we change the very foundation and the framework for our country, we can put all the civil rights laws that we want out there. We can have all the reconstructions that we want, but it will not bring about the change that we need until we change our behaviors and how we do what it is that we do. The Civil Rights Act of 1964, we are now nearly 60 years past that. Yet we have 5 Black individuals who are CEOs of Fortune 500 companies, 2 of them being Black women. We know that women continue to earn less than what men earn in the workplace. We know that from 2019, the median household the median household wealth of white families was nearly $200,000. The median household wealth of Black families was a little over $20,000. A big, huge gap, nearly 60 years after the Civil Rights Act of 1964. We didn't do as the Kerner Commission indicated. We didn't make a major change. Instead, we invested our time on criminalizing and through punitive measures. That is the result of that huge gap that we continue to have. So therein lies the problem and the role that the law has had And certainly now I want to get into what we as lawyers can do to help progress us towards a more equitable society. And I want to start that by talking about where I have come from in my legal journey. So this is me back in 2000. Look quite a bit different. I mean, I was much younger there, but still you could see all the other ways in which I look very different from that. This is my photo for Boris. I had on a turtleneck and I guess a suit jacket on top. I really hate turtlenecks, so I can't believe I did that. But you see those little bitty earrings there. You can see what I have on now. I can assure you that though you can't see my nails, they did not look like what you see here. When I came into the law firm, I was the first person in my family to practice law. So with the practice of law, I understood it from what I saw on television. At the time, and what has continued now, is that with the legal field, it is very dominated by white men and had been for the hundreds of years before I came to practice it. So when I came into the law, just like everyone else who was coming to the law, we were coming to an environment that had been created and molded by a specific demographic, which I did not fit into. And so this frame that I was coming into, I was going to have to adjust myself. And you can see from physically how I adjusted myself. I was talking with Professor Cole last night about having to wear pantyhose. I told her, I don't know how many young people even know what pantyhose are. She talked about she couldn't even find some. She was looking for some, but had to wear pantyhose, wore skirts and heels, didn't wear pants or anything like that. In addition to how I looked, I also, in the terms of how aggressive I was and how competitive I was, all came from what I understood I needed to be as a lawyer. I wanted to be a rainmaker. I wanted to be successful. And therefore I was going to go in, do whatever it was that my clients needed to make them successful. And it didn't matter who I may have harmed while doing that. I was convinced that the best way to advance my career and to be a great advocate was to negotiate the smallest settlement possible. Years ago, I remember I would brag, and I see Lena out here, who was a part of my legal team at Abercrombie & Fitch. But I recall doing a settlement that was public, so I can mention it. But it was a settlement that was about 150 pounds. At that time, that was probably close to 300 USD. But you know, I would brag about, look at this little bitty settlement that I was able to do for the client. But that is what really motivated me. I also thought being a great advocate was to convince the opposition that they did not have a case at all, even if they did, and even if justice would be served, if they received some sort of level of benefit from the outcome. I was willing to allow any of that because of my fierce advocacy for my client, because I felt that to win and to win big, I needed to take complete advantage of whoever was on the other side. In other words, I thought the best type of advocacy was to help my clients meet their financial and business goals with little regard to the treatment of their employees, business partners, their prospective consumers, or society at large. This is a time in my practice where I was not a part of progress. I was a part of hindering it. Again, an employment lawyer, I understood that with clients that there may have been an interest in doing just what the law indicated that you had to do. So under Title VII of the Civil Rights Act of 1964, in order to prove that I have been discriminated against, I have to show that I was intentionally discriminated against. So microaggressions and things that didn't hit that bar, well, is the employer going to care about that? Is it any action that's going to take place? And there was a time in my career where I would come in the room and say, well, if you didn't hit this threshold, no, and even if you did hit this threshold, taking advantage of the fact that I represented a big client against an individual person, what could I get being on the side of the negotiation table where I had all of the power? As opposed to what I should have been doing, which is what could I advise my clients to do to get ahead of the problem? What can we do in terms of the culture, in terms of putting people first, so we don't get to the problem of having people who feel like they have been mistreated? Now, fortunately, I did not stay in that place for too long in terms of just not really taking into consideration how people were being treated. And I did evolve, thankfully. And as I continue to practice, my focus on my success and thereby the success of my clients has been to make sure that it's not at the detriment of others, and to make sure that I get to a place where I'm thinking more holistically. I'm thinking about society at large and the impact on society at large. As I better understood how corporate actions impacted employees and their families, and how injustice and inequity hurt communities, I realized that I was a better advocate if I helped my clients to preemptively act in the interest of their employees and consumers, rather than only serving the client's bottom line. By doing so, my clients would positively affect the health of employees and garner greater loyalty from consumers, all reverting back to the company, making their overall impact stronger. So I went from a personal self-motivated action that placates clients and their uninformed position and leads to decisions that hinder societal progress, went from that to a better advocacy informed by equity and fairness that considers a just and equitable society, progressive action that creates distance from biased traditions and standards. And making that transition, I had to go from a place of only considering what the client may have thought it wanted to do to a place of informing, using those skills that I had to persuasion and convincing to help to understand from a contextual perspective what impacts certain decisions might have. I read a law review article recently by Dean Conway, who's at Penn State Law School. She wrote a law review article for the Utah Law Review, and she talks about anti-racist lawyering, and she talks about creating anti-racism in law schools. She says here, but the lawyer, by virtue of training and experience, has a special and affirmative duty to promote the rule of law, especially on behalf of the most vulnerable members of our society. This means that there is an extra layer of responsibility for the lawyer. If there is an extra layer of responsibility on the lawyer, then there is, by definition, an extra layer of responsibility on the legal profession and the legal academy to recognize and then eliminate systemic racial inequality. With that quote that I just read, and from my experience over the years, I really come to the conclusion that to be the most effective advocates, to be the best lawyers that we can, it requires us lawyers not to reinforce the legal culture that is driven by tradition, incentives, and rituals that stem from a singular view of professionalism and how it is that we are supposed to lawyer. Those ways have traditionally only benefited those who had originally created it. We have to be a part of change and changing how we act as lawyers. So that gets me to 3 ways in which I believe as lawyers through negotiation, we can be a part of radical transformation and change. So this first thing I have here is redesign how we negotiate. That is where I come with respect to the house analogy. We have to change the foundation, we have to change the walls and change all of the different things. And we have to think differently and act differently in order to do that. This, you may not, oh, you can see the words pretty well there. Inclusive design. This is something that we use at Lululemon. It's something that I am a big believer in, inclusive design. This is thinking more creatively. It is being willing to approach how we do what we do in a different way. It is making sure that we focus on the most marginalized in society, by which we will then have a positive impact on the whole. This cartoon I really like, and what you see here is a man who is trying to get snow up, So there is a ramp and then there are stairs. You can see that there is one kid in a wheelchair, the others are standing and do not need the assistance of a wheelchair. The worker is getting the snow off the steps because that makes the most sense. If we get the snow off the steps, the vast majority, all but one of these kids are gonna be able to get in. Once I get done with the steps, I can go do the ramp. Now, when we get caught up in just traditionally how we do things, kind of just this rote way, this makes sense. First do the steps, then I do the ramp. And here the kid in the wheelchair says, hey, can you go ahead and clear off the ramp? And the guy says, you know, probably politely, I will get to the ramp, but let me clear this off first so that all the other students can get in. And then the kid in the wheelchair says, well, if you clear off the ramp, then all of us can get up. It's not just me, all of us can get in. And with inclusive design and the way that we have to approach negotiation, the way we have to approach what we do as lawyers is to think differently, to take a moment and to really just think, take the time to think strategically, how can we get to a result in a better way that can benefit society, can benefit the most. So that is what I mean when I talk about inclusive design. So in redesigning how we negotiate, first I have is how do we define the win? We have to get away from the binary thinking of in order for one person to succeed or win or to benefit, that someone else has to lose. Where is that place in between where it's not that you have to have a winner and a loser? So getting away from that binary thinking. We have to redefine how we think about losses and how. We have to get more into context and figure out the impact of whatever the decision is that comes from the negotiation that we have participated in. We have to think about the commodification of people and humans. Again, and this really does come from my practice of law. Early on, it didn't matter to me the human. Again, it just mattered to me the win. It didn't really matter to me the impact that it was going to have. I didn't think about the impact on that particular individual or on society at large, and we really have to think about that. An example that I like to use regarding this goes to Ford Motor Company, and this is probably a case that you all have heard about in law school, but in the 1970s, Ford had the Pinto car. Does anybody remember the Pinto? Did anybody have a Pinto? Did you have a Pinto? I know that you have the Saabs, okay. We were talking about that last night. Okay, so we had the Pinto, and then they also had some sort of lightweight pickup truck. And so with these two vehicles in the 1970s, there was something that was going on with them that, well, they would just combust, just blow up. And then of course, injure or kill the people who were driving them. When this issue came to the Ford Motor Company leadership, they started to look into this and they started to analyze to figure out, okay, what does this mean? And when they did the research, they learned that if they had $49.5 million that they set aside, that would be enough that if these Pintos and these trucks blew up, then the people would come, they would make whatever claims they would make. Of course, they would have their lawyers do whatever they could do to give just the minimum amount of money, and it would cost about $49.5 million. So we put that aside, go ahead and let the Pintos and the trucks blow up, and then we'll do the payouts. They then also looked at, okay, well, what would it cost us to actually fix it so that they do not blow up and so that people aren't injured and people do not die? And it's $137 million to fix it. So when you're thinking about this and you're not thinking about people as humans and it's just about the business and the bottom line and how it can succeed, you look at a difference of $87.5 million, and it could lead one to say, let's just go ahead, reserve the $49.5 million and deal with it when these things blow up. When looking at this particular case, Dr. Joy DeGruy in post-traumatic slave syndrome talked about this particular example. And there she talked about, though the actuarial analysis was correct, mathematically speaking, it proved to be incomplete and quite short-sighted, very binary thinking. It failed to take into account the positive effect that recalling and repairing their cars would have in the Ford automobile owners and potential buyers. So just looking at, either we pay out this amount of money or we pay out this amount of money. Not looking at what can we do that actually would, in a positive way, make sure that people aren't being killed or injured, and also garner some sort of loyalty and respect for the company and brand. Didn't look at those things. In addition to saving lives, recalling and repairing their cars would certainly have added to the public's respect for and confidence in Ford Motor Company. In the grand scheme of things, Ford's actions might seem relatively inconsequential when you're looking at it just at the numbers. When material gain becomes the God before which all must be sacrificed, even one's humanity, all manners of crimes and pursuant justifications become possible. So here, we just have to remember that we're dealing with humans. And we're dealing with how humans are impacted. And really need to invest our time in doing the research of what impact does this particular decision, what could it have on people, people involved today and then people in the future. knowledge and research. So when we get ready to go into negotiations, when we're getting ready to give advice, we of course make sure that we are deep into comprehensive research and critical thinking. We need to make sure that we continue to do that. In fact, it is essential for us as lawyers to help accelerate our path towards equity, to make sure that we're well informed. We should make sure that we understand race and culture in the United States. We should make sure that we understand what drives our society, those who have and those who have not. We should make sure that we understand why that is the case and how whatever it is that we're doing impacts humans. That is something that we all should make sure that we understand. If we're going into a mediation, even if it seems like, or a negotiation, and it seems like something that is not very big of an issue, really look and make sure that you understand the impact that a resolution may have. I was doing some research some time ago and was reading a fact pattern that was talking about a Latina woman who had applied for a particular position at a company. And this woman had come from a background of working with companies that had paid her less than other comparable people. And so she was used to making lower wages. When she went to a particular employer, she was willing to come in at, let's just say $100,000. She was willing to come into the company at $100,000. The people in that department who were coming in and who were there, let's say that their base was $120,000. Now, when looking at this, there may be some that say, okay, if we're going back and forth and negotiating with her, we can get her easily at $105,000, save that $15,000, and great. Maybe we could even put it towards some sort of initiative or program. That may make sense. We're saving some bit of money. We may be able to stretch our dollar further. But when we think about this, what is the experience of this woman once she is hired? At some point, when you're looking at gender equity in your organization, what impact will it have? How valued will she feel when she learns what other people are making? So taking into context the history of this particular woman, the history of particular groups in the United States and the pay gaps and inequity of pay, we should consider those things and not use against people their immutable characteristics, not use against people those things that give us more authority or more power at the negotiation table. We have to make sure that we are considering our employees again as humans and not, as you see pictured here, kind of stepping on them. This also, my third thing here is courage. All of this takes a lot of courage in order to do things differently. There are a lot of people, they don't like change. Going against the grind, swimming upstream when everyone is going a different way can be very difficult. But we need to have the courage to stand up and to be lawyers who can push back, lawyers who are willing to negotiate differently, lawyers who are willing to be creative and come to different solutions that take into consideration how others in the larger group may be impacted. Through systemic racial inequality, though systemic racial inequality is embedded in America's system of laws, the duties and responsibilities of lawyers should be towards transformative change that will give meaning to the democratic ideals of equality and justice. This work is not wishful. It is required of if American democracy is to survive and flourish. Those are the words of Dean Conway in that Utah Law Review. So my ask for us is to dare to do things differently. To no longer is our field governed by one specific demographic as it had been for hundreds of years. And surely we are at a point where we must consider other points of view in how we practice law and how we negotiate. So we must be courageous enough to go against the grain and to practice law, to negotiate in a manner that benefits the marginalized and therefore the masses. So thank you. And I think I'm going to open it up for questions.
There's some questions we have on Zoom, but others just raise your hand in the room. Okay. Zoom question, but if you move your hand, I will call it. So, with respect to the wheelchair ramp, a person writes here, if you're asking people to question their assumptions, their norms, their ways of working, how do you help the young attorney, perhaps the young Stacia, help reorient an older seasoned attorney who's been taking the let's just shovel the stairs approach for decades? How do you help that young attorney operate in a let's think differently, let's move to the wheelchair ramp? What advice do you have for them?
Yeah, the first is to go, of course, with having the courage to do it. I mean, it can be very difficult. I was in your class earlier today and talking with your students, and I brought up Ally McBeal. I don't know if any of you all remember that, but I can recall being in a law firm and feeling like Ally. There was an episode where she just kept shrieking in the chair. She was sitting across from a male partner, and she's talking and talking. It's like she's getting smaller and smaller. Sometimes that's how it feels. But as young lawyers who are about transformative change, we have to have the courage to speak up and to convince our partners, colleagues who have been doing what they've been doing for a while, that we really need to do things differently. I know that myself, now having practiced for a while, that there are certain things that younger folks have to inform me of. You know, like, Stacia, well, I think we should think about something differently. Not everyone's going to listen to us. Not everyone's going to listen to you. Not everyone is going to be convinced by what you're saying, but it's so important that we have the courage and we try. That we bring examples of how folks can be impacted. The way that I talked about the civil rights movement from slavery until today and the impact and those threads that continue to impact us as a society, how can you talk with partners to say, this is the impact that these things will have? It is not just about dollars and zeros, it's about people feeling valued. And we know most certainly over the past 10, 15 years that employees have really been rising up. Consumers have been rising up, boycotting, and labor unionization is on an all-time high recently. And this is because people are starting to push back. So whatever it is that we have to do to convince people that there is a different way, and that different way values people, it is worth the try.
Any questions in the room right now? Oh, wonderful. Introduce yourself for the Zoom audience.
Okay, it's Ellen Deason. I was really interested in your personal transformation, and I wondered what kind of negotiations did you have with yourself in essentially rebuilding your own house? What led to that process? Because you've been talking about working with others, but obviously there's also an internal process.
Yeah. I mean, part of it is simply because I'm a Black woman. And so going through and as an employment lawyer, though I might have gone into it thinking about how much money can I make, how successful can I be, after a while, you know, sitting across from employees, sitting across from people who were really impacted by decisions that were being made by clients that I represented, really allowed me to see through empathy and seeing myself in them that this may not be the right way. And certainly getting into doing more research about race and culture and the progress that we haven't made, I just didn't want to be a part of that problem any longer. And of course, also experiences as a Black woman that I've had in the workplace, I didn't want to continue to do to people what may have been done to me or what could have been done to me.
Pretty good at Sam.
Please.
Sorry. So you mentioned being a labor lawyer. You mentioned unions having higher participation rates in the last couple decades, getting higher every day. Some of our larger unions are also starting to democratize and go to a one worker, one vote system. So with this is specifically asking as a labor lawyer, with participation becoming wider for groups such as unions, what do lawyers in that field need to do to focus on equity and inclusion with an even larger base to have to persuade?
Yeah, that's a good question. My mind is going to a conversation I had with a really large company that was talking about labor organization. I was talking about how big their company was and being concerned that someone coming in who had more limited experience with small organizations may not be able to kind of deal with that larger employee base, or have to convince that many more people. And to me, my response at the time was that it still is the same problem. It still is the same issue. People not feeling valued. If it's 10 people or 10,000 people or 100,000 people, whatever it might be, you still have the same arguments and the same convincing that you need to do, no matter how many people it is that you have to convince, no matter how many people it is that you have to represent. If you have just 10 people who are just polarized and I'm not gonna move, if you have 100 people, you're still probably gonna have to do the same amount of work if you have people who are taking those specific positions. But again, it is most certainly worth the work in going in. As lawyers and with negotiation, we always kind of look at the room and with personalities, you get in there, you build relationships. Even if someone is on the opposing side, and you start to see through relationship how you can get people to understand certain things. And it's through relationship, again, even if it's the opposition, that we can help to try to convince people of what we should be doing as a society.
Couple questions online about bias.
Mhm.
So what methods have you found to be particularly effective in helping individuals work through their implicit biases? And as mediators, particularly, mediators might be in a position, Stephen writes online, to suggest more effective approaches to cases that might not otherwise settle. So how do you think through implicit biases, strategies for addressing implicit biases, and for mediators who are thinking they know the answer to the parties' dispute?
Yeah. From that perspective, we all understand that if we're going to be a mediator in a case, we all understand that we have bias. It's something that is a part of all of us. And none of us should feel that we are at a place that we have arrived and we no longer have bias and we can go into a situation and mediate a matter and not have our bias impact. We most certainly have the bias, and it most certainly will have an impact if we are not checking it. So it's really important that we understand the biases that we have. It's important that we slow down and really consider what we're doing, because the slower that we are acting and responding, the less bias will have an impact. We have to make sure that we're understanding, again, context and background when going into a mediation. Who's coming to the table? What baggage may they be bringing to that table? We have to be willing to be creative in coming to solutions, and to solutions, again, just as with negotiation, thinking about how those solutions will impact the people involved and then society at large, as with the example with the Latina woman.
Over here, any questions on this side of the room? Oh, Professor Cole, you go ahead and get started while I walk over.
Okay. Well, thank you so much, Stacia. It's just
Sure.
great to see you here and give such a thoughtful and inspiring speech. I wanted to ask a little bit about your role at Lululemon. And do you assist the client in making those good decisions? Because sometimes it's not only convincing the lawyers who are involved in an employment discrimination case that a different approach is important, or that there are other considerations in this particular instance, but the client who's just looking at their bottom line and saying, well, we could settle this for a very small amount, and we think this was a frivolous claim. You know, what's the role of the young lawyer or the partner at the law firm or someone within the organization to help enlighten the general counsel's office or the client itself, whoever's the ultimate decision maker?
Yeah. Most certainly, when I practice law, when I'm acting as a DEI professional, it has been very crucial and important that I have the courage to speak up about whatever the matter might be. That's kind of the first thing, is the courage to do so. Also, where I talked about relationships, in my time in corporations at A&F, at Lululemon, at Microsoft, it was building relationships with people who make the decisions to the point where they trusted me. And when I came in and I talked about how somebody or a community might be impacted, they really did listen. At Lululemon, our CEO, our senior leadership team, they really are invested in making a difference. They really are invested in the well-being of everybody throughout our collective. That's our employees and our guests, our business partners also. And so they listen to me. So having the courage, making sure I have those trusted relationships, and then having a group of people in leadership who actually want to do things better. So who actually listen and then act on what I'm advising.
Question? Any questions from the audience here? Abby, okay, wonderful. shoot a fragment down.
Hi, I was just curious, I think on one of your earlier slides, you had something about corporate responsibility. And now that you're at Lululemon, you were at Abercrombie, I was wondering if you could talk a little bit about what corporate responsibility holistically looks like for you beyond just stuff with employees, but what does it look like in terms of the whole corporation, especially with DEI stuff?
Yeah, so, so corporate social responsibility, we kind of have gone from that language to ESG, and ESG is more of a holistic way of looking at sustainability, looking at governance, and looking at DEI. And so really ERG is the better, or ESG is the better way to kind of talk about that. And it really is a corporation understanding that even though you make widgets, that is not the only thing that you do. You do have an impact on society. You have an impact on the environment. You have the impact on people. You have the impact on reinforcing that house and that foundation that I had up. And so corporations, when they understand the impact, the larger impact that they have, and they are responsible in making sure that their carbon footprint, where they're making sure that the impact that they have on stereotypes that they put out in their marketing, with how they are treating certain people in the workplace. When they are responsible enough to take care and make sure that they are not reinforcing anything, that they are not causing harm, and in fact, are actually doing good and going against the negativity that's in society, that is where corporations must be. Again, it's no longer okay to just make my widgets to go about business. You really do have to be concerned about all kinds of other things outside of the widgets. You know, I'm not even sure what a widget is. I just know from law school, we talked about widgets. I don't know if a widget is a real thing or just your products, but I always go to widgets. So whatever those are.
Hello. So
Hi.
you talked about having a whole career to get where you are today, and the transformation from that young attorney starting at 4A's to now. What is your advice to young attorneys who share your values, but also understand the grind of going into firms and having to drive to try to be that rainmaker? Is it a be who you can afford to be, or is there a path early on for attorneys to bring that value to the workplace to try to make those changes?
You know, that is so, such a good question. I tell you, with me being a Generation Xer, I most certainly was of the mind that I was to be the woman that you saw up on the screen. So my hair was going to be pressed straight. I was going to do what I needed to do to fit in that box in order to get to a place where now you see how I look. So it was like I needed to start and be a part of the process. That's how I felt. That was my only way I felt to be successful. I think it's much different today. I think especially with younger folks that are coming up, I was talking with someone in the class earlier today. It's like, no, I am who I am, and I am not going to be worked half to death and everything else, and are more willing to speak up. And I think that there's power in numbers. And I think with generations now, they're saying, no, we're only going to take so much. And you can see that in the corporate space right now. There is a lot more of us in corporations really listening to our employees, really understanding the importance of mental health and well-being. And with all of that, we are also having employees who are saying, no, I need to be able to do this, or I need to be able to do that. So now I would say it's different from when I was coming along. And when I'm talking about this radical transformation, we really do need people to be bold and courageous from the get-go and be able to come in and say, no, you know, we're going to have to do this thing differently. And this is the reasons why. It's a scary thing to say. And of course, I'm 22 years out. I'm like, I did what I had to do. I'm here where I am. But I do hope that you all and people coming into the law do have the courage from the get-go.
Time for just a couple more questions. One from online, one we can expand on. Do you believe that the presence of biases or the effects of biases change when they move from in-person communication to an online communication medium? And really, have you noticed a shift in biases and structures since we have shifted online?
Yeah, I've seen different things. You know, there were some people that I heard early in COVID that said that the Zoom screen somehow took away bias, that all of us had the same sort of square and we were all there. And I that to me just didn't resonate. I'm like, you still can see who you can still see I'm a Black woman sitting across here with these long dreads in my hair, my long nails. So I'm not sure how the box does that. There were some people in actual research that said that took away bias. I also saw research that indicated that when you had the Zoom screen, and let's say that Bill was on it in a Zoom, and Bill's kids went running through the room. People were like, oh, Bill. If I were on the screen and my kids come running through the room, it's like, oh, she's so unprofessional. So you still saw that was showing up even in the Zoom world. Now, also, as we return to work, I have also seen research that indicates that people from marginalized communities, in particular Black women, are concerned about going back into the work because of the culture that they left pre-COVID and feeling that there was some sort of protection of being behind the screen. Corporations have to work on that. Whatever was going on pre-COVID, you need to fix that. It's not saying, okay, it's remote or okay, you can just be remote. You need to fix what's happening in the culture because I can guarantee that what was happening face-to-face in 2019 before COVID is going to seep over even into this Zoom world in terms of over-talking individuals, over-talking marginalized individuals or women. I've seen that. People having microaggressions. I've seen where people have been on Zoom and they're using their hands and that sort of thing. They're from a marginalized community and it's like, oh, they're being aggressive even though it's through Zoom. So it still will bleed over into it. I don't see a big difference in terms of bias on either side. It is something that has to be dealt with by the corporation, no matter where it's coming from. Did you have your hand up? Or was you might have been moving.
I did have it up.
Oh, you do? Okay.
Yes, thank you.
Hello, and thank you for sharing with us today. My name is Jason Moore, working in the college's AD, or Assistant Director for Inclusive Excellence and Student Success. And so my question to you, a lot of times, whether it be firms or distinguished guests like you, we share with students about what they can start doing, after they, pass the bar or, just after graduation. But do you have any words to share, I guess, final thoughts, because I think we're out of time, final thoughts about things that we can actively do as students now, whether you're 1, 2, or 3, or even in other programs as well. So things we can do now versus in 2 or 3 years.
Yeah, in this area, in the realm of what we're talking about today, I just think it's so important for education and knowledge and really educating ourselves. Education truly is powerful. And I don't mean your legal education. I mean education on what is happening in the United States so that when you do start to practice law, you can better understand the impact of the decisions that you're making and the advice that you're giving. So yeah, spend all the time, just not that you all have extra time in all your law classes, but listen to a podcast when you're driving or what have you. So. Are you coming to pull me off stage? I feel like she's coming to do the sweet thing to get me off. Okay. In closing, I'm just saying. Oh, no, thank you.
Thank you.